Probate costs American families billions in fees and months of waiting, but it is not inevitable. There are 5 legal methods to pass your assets directly to your family, and most of them are either free or cost less than a few $100s to set up. Today, I'm showing you exactly how to bypass the court, the judges, and the attorney fees. Method number 1 is the fastest and cheapest: beneficiary designations. The fastest, cheapest, and most overlooked method of avoiding probate costs nothing and takes about 20 minutes. It's called a beneficiary designation, and most Americans have access to it right now on accounts they already own. Here's how it works. Most bank accounts, investment accounts, and retirement accounts allow you to name a beneficiary directly on the account. When you die, the account passes immediately to that person, completely outside of probate, no court. No filing, no waiting. For bank accounts, this is called a payable on death designation, or POD. You walk into your bank, fill out a simple form, and name the person who receives the funds when you die. It costs nothing. The beneficiary has no access to the account while you're alive. The moment you die, they present a death certificate and the funds transfer directly to them, often the same day. For investment and brokerage accounts, it's called a transfer on death designation, or TOD. Same concept, same process. You contact your brokerage, fill out a beneficiary form, and the account passes directly at death. For retirement accounts, IRA, 401k plans, 4013B plans, you already have a beneficiary designation form on file. The question is whether it's current. Outdated beneficiary designations on retirement accounts are one of the most common and most expensive estate planning mistakes. People name an ex-spouse, a deceased parent, or nobody at all. When that happens, the account goes through probate, or worse, passes to someone you never intended. Here's the most important thing to understand about beneficiary designations. They override your will completely. If your will says your daughter gets everything, but your savings account still has your brother listed as POD from 20 years ago, your brother gets the money, not your daughter. The account designation controls, period. Review every account you own. Make sure every POD and TOD designation is current, accurate, and reflects what you actually want. This one step, completely free, could save your family months of waiting and thousands in probate fees. Method 2, joint ownership with right of survivorship. The second method is joint ownership with right of survivorship, and it's the most widely used probate avoidance tool in America. Here's the basic concept. When 2 people own an asset jointly with right of survivorship, and one of them dies, the surviving owner automatically becomes the sole owner. No court, no probate, no process. It happens by operation of law, meaning it's automatic. This is how most married couples own their home. When one spouse dies, the home passes directly to the surviving spouse, no probate required. All the surviving spouse needs to do is file a death certificate with the county recorder's office to update the title. Joint ownership with right of survivorship works for real estate, bank accounts, vehicles, and investment accounts. Setting it up for real estate requires recording a new deed with the correct language. Specifically, the deed must say, joint tenants with right of survivorship. Simply adding someone to a deed without that language may not create survivorship rights. It depends on your state. Here's the important limitation. Joint ownership only avoids probate for the first death. When the second owner dies, when the surviving spouse eventually passes, the asset goes back through probate unless other arrangements are in place. A home owned jointly by a married couple avoids probate when the first spouse dies. But unless the surviving spouse sets up additional planning, the same home goes through probate when the surviving spouse dies. There's also a control issue. Once you add someone as a joint owner, they are a co-owner immediately, not just at your death. If you add your adult child as a joint owner on your bank account, they have full access to the funds right now. If your child has debt problems, creditors could potentially reach that account. If your child goes through a divorce, their spouse could have a claim to it. Joint ownership is simple and effective for married couples, but use it carefully when adding non-spouses as co-owners. The third method is the Revocable Living Trust, and if you've been watching this channel, you already know what it does. A living trust holds your assets during your lifetime and distributes them directly to your beneficiaries when you die, completely outside of probate. No court, no judge, no public record. Unlike beneficiary designations and joint ownership, a living trust can cover everything at once: your home, your bank accounts, your investment accounts, your personal property, in one document. It works across multiple properties in multiple states. It protects you during incapacity, not just at death, and it gives your successor trustee complete authority to distribute your estate without any court involvement. The full explanation of how a living trust works, what goes inside it, and the most common mistakes is covered in our video 4, link in the description. For this video, here's the key takeaway. A living trust is the most comprehensive probate avoidance tool available to American families. It covers situations that beneficiary designations and joint ownership cannot. But it costs between $400 and $3,500 to set up, and it only works if it's funded, meaning your assets must be physically transferred into the trust. For most families who own a home and have significant assets, a funded living trust is the gold standard. Method 4. Lady Bird Deed. The fourth method is one most Americans have never heard of, but for homeowners in certain states, it may be the single most powerful tool available. It's called a Lady Bird Deed, also known as an enhanced life estate deed. Here's how it works. A Lady Bird Deed lets you transfer your home to a named beneficiary when you die, completely outside of probate, while you retain full control of the property during your lifetime. You can sell it, you can mortgage it, you can change the beneficiary, you can revoke the deed entirely. Your beneficiary has no ownership rights, no access, and no say over the property until you die. At that point, title transfers automatically. Think of it as a transfer on death designation for your home. Same concept, just applied to real estate. The cost is remarkably low. A Lady Bird Deed typically costs between $200 and $500 with an attorney, and in some cases as little as $30 if you prepare it yourself. Here's the catch, and it's an important one. Lady Bird Deeds are only available in 5 states: Florida, Texas, Michigan, Vermont, and West Virginia. If you live outside these 5 states, this option is not available to you, and you'll need to use a living trust or another method for your home. For homeowners in those 5 states, especially Florida and Texas, where real estate probate costs are significant, a Lady Bird Deed is often the most cost-effective way to keep your home out of probate without the expense of a full living trust. A woman in Florida used a Lady Bird Deed to transfer her home to her daughter when she passed. The deed cost $350 to prepare and record. The home, valued at $380,000, transferred to her daughter in a matter of days. No probate, no attorney fees, no court. A living trust would have accomplished the same result, but cost 6 to 10 times more to set up. If you live in one of the 5 states, and your primary goal is keeping your home out of probate, a Lady Bird Deed deserves serious consideration. Method 5. Small Estate Affidavit. The fifth method is not a planning tool, it's a safety net. And it's one most families never know about until they need it. It's called a small estate affidavit, and in most states it allows heirs to collect assets from a deceased person's estate without going through full probate, as long as the total estate value falls below a certain threshold. The threshold varies significantly by state. In California, the small estate threshold is $208,850 as of 2025. In Texas, it's $75,000. In Florida, there is no formal small estate affidavit, but estates under $75,000 may qualify for a simplified summary administration process. Most states have some version of this, either a small estate affidavit, a simplified probate procedure, or both. Here's how it works in practice. If someone dies with an estate below the state threshold, and with no real estate in their name, An heir can present a simple notarized affidavit to the bank, the DMV, or the brokerage, stating that they are entitled to the assets. The institution reviews the affidavit and releases the funds. No court filing, no judge, no probate attorney. A man in Illinois lost his father with a savings account worth $68,000, below the state's $100,000 threshold. Instead of filing for probate, he completed a small estate affidavit, had it notarized, and presented it to the bank with a death certificate. The bank transferred the funds within 2 weeks. Total cost? About $50 for notarization. The limitation is clear. This method only works for smaller estates and typically cannot be used if the deceased owned real estate in their name. But for families dealing with modest accounts and no property, it is the fastest, cheapest path available. Which method is right for you? So which of the 5 methods is right for your situation? Here's the honest answer. Most families need more than one. Beneficiary designation should be in place on every account you own, regardless of what other planning you have. They cost nothing and cover your financial accounts completely. Joint ownership works well for married couples on shared assets, particularly the family home. Use it carefully with non-spouses. A living trust is the right choice if you own a home, have significant assets across multiple accounts, or want comprehensive protection that covers everything in one document. A ladybird deed is worth considering if you live in Florida, Texas, Michigan, Vermont, or West Virginia, and your primary goal is keeping your home out of probate at the lowest possible cost. The small estate affidavit is not something you set up in advance. It's a tool your heirs use when the time comes, if the estate qualifies. The most common and most effective combination for American families: a funded living trust for your home and major accounts, beneficiary designations on every retirement account and life insurance policy, and a pour-over will as the safety net for anything you missed. Let me bring this together. Probate is not inevitable. It is a default, what happens when you don't plan. And every one of the 5 methods we covered today exists specifically to replace that default with something better. Beneficiary designations, free, 20 minutes, covers all your accounts. Joint ownership, simple, immediate, works for shared assets. Living trust, comprehensive, private, the gold standard for families with real estate. Ladybird deed, low cost, powerful, available in 5 states. Small estate affidavit, the safety net your heirs may never need to use. You don't need all 5, but you probably need more than one. In the next video, I'm going to walk through the complete estate planning checklist, everything you need to have in place, in the right order, to make sure your family never has to deal with probate, frozen accounts, or court delays. If you want one video that ties everything together, that's the one. I'll see you there. If you found this video useful, don't forget to hit like and subscribe. It helps more families find this information.